I'll be reading cases on every topic of taxation decided by the Supreme Court in 2018 and 2019. So if you're not yet subscribed, hit the subscribe button. Thanks.
Taxation due process. The case is Commissioner of Internal Revenue versus Filipinas, Shell Petroleum Corporation, GR number 197945, July 9, 2018. First Division. Facts. Shell and Petron are domestic corporations registered with the Board of Investment, BOI, and on different occasions separately sold their products to other BOI registered export entities that use tax credit certificates, TCC, for their purchases. The BOI registered export entities later on assigned their TCCs to Shell and Petron, which was approved by the Department of Finance, or DOF. Thereafter, Shell and Petron sought DOF's permission to use the said TCCs for settling their excise tax liabilities. DOF then issued a tax debit memoranda, or TDM, in their favor, which was subsequently presented to the Bureau of Internal Revenue, BIR, for payment. Later in 1998, BIR sent collection letters stating that the payments made through the TCCs were invalid and hence they were still liable for deficiency taxes. BIR also issued a warrant of garnishment against Shell. The TCCs were subsequently cancelled by DOF. Pursuant to the cancellation, BIR issued separate assessment letters to Shell and Petron in 1999. In 2002, another collection letter was sent by BIR to Shell. The issue: can BIR collect deficiency taxes by mere issuance of collection letters? The ruling is no. BIR cannot collect deficiency taxes by mere issuance of collection letters. Under the law, the BIR's power to collect taxes must yield to the fundamental rule that no person shall be deprived of his or her property without due process of law. The BIR must first make an assessment, then enforce the collection of the amount assessed. Hence, the BIR may only enforce collection when it has accorded the taxpayer administrative due process, which includes a valid assessment. In this case, CIR did not issue at all an assessment against Shell and Petron prior to the issuance of the 1998 and 2002 collection letters. Absent a previously issued assessment supporting the collection letters, CIR's attempt to collect through said collection letters, as well as subsequent warrants of garnishment and distraint and or levy, are void and ineffectual. Thus, the BIR cannot collect deficiency taxes through collection letters alone. Under double taxation, City of Manila versus Cosmos Bottling Corporation, GR 196681, June 27, 2018. Facts. The City of Manila assessed Cosmos Bottling Corporation, or Cosmos, local business taxes. Cosmos protested the assessment through a letter arguing that, among others, the collection of local business tax under Section 21 of the Revenue Code of Manila, RCM, in addition to Section 14 of the same code, constitutes double taxation. The city treasurer denied the protest. The City of Manila argued that there is no double taxation because the tax imposed under Section 21 is imposed on a different object and of a different nature as compared to that in Section 14. Issue: does the collection of local business tax under Section 21 of the RCM in addition to Section 14 of the same code constitute double taxation? Ruling: yes. The collection of local business tax under Section 21 of the RCM in addition to Section 14 of the same code constitutes double taxation. Under the law, there is direct double taxation when taxes of the same kind or character are imposed on the same subject matter for the same purpose, for the same taxable period, and within the same taxing jurisdiction of the same taxing authority. While the City of Manila could impose against Cosmos a manufacturer's tax, Under Section 14 of the RMC, it cannot at the same time impose the tax under Section 21 of the same code. Otherwise, an obnoxious double taxation would set in. Indeed, the following imposition under both Sections 14 and 21 of the RCM would constitute double taxation. On the same subject matter, the privilege of doing business in the City of Manila. Number 2, for the same purpose, to make persons conducting business within the City of Manila contribute to the city revenues. 3, by the same taxing authority, which is City of Manila. 4, within the same taxing jurisdiction, it's within the territorial jurisdiction of the City of Manila. 5, for the same taxing periods per calendar year. And 6, of the same kind or character, a local business tax imposed on gross sales or receipts of the business. National Taxation, Bureau of Internal Revenue, BIR issuance. The case is Confederation for Unity, Recognition and Advancement of Government Employees, or COURAGE et al. Versus Commissioner, Bureau of Internal Revenue et al. TR 213446, July 3, 2018. Facts. Commissioner of Internal Revenue, CIR, issued the Assailed Revenue Memorandum Order, RMO, number 23/2014, in order to clarify and consolidate the responsibilities of the public sector to withhold taxes on its transactions as a customer on its purchases of goods and services, and as an employer on compensation paid to its officials and employees. Confederation for Unity, Recognition and Advancement of Government Employees, COURAGE et al., organizations, unions of government employees, alleged grave abuse of discretion on the part of the CIR in issuing RMO number 23/2014 as it classified as taxable compensation, allowances, bonuses, compensation for services granted to government employees, which are considered by law as non-taxable fringe and de minimis benefits. COURAGE further claimed that the subject RMO constitutes a usurpation of legislative power and that it violates the Equal Protection Clause as it discriminates against government officials and employees by imposing fringe benefits tax upon their allowances and benefits as opposed to that of the private sector, the fringe benefit tax on which is borne and paid by their employers. Armando Yanga et al. Likewise challenged RMO 23/2014 on the grounds that the CIR is bereft of any authority to issue the assailed RMO and that it violates fiscal autonomy. Issues: A. Is RMO number 23/2014 valid? B. Is RMO 23/2014 constitutional? Ruling. On letter A, Sections 3, 4, and 7 of RMO 23/2014 are valid, whereas Section 6 is invalid. Section 3 speaks of the obligation to withhold on compensation paid to government officials and employees, while Section 6 enumerates income received by the officials and employees in the public sector, which are not subject to income tax and withholding tax on compensation. The assailed section simply reinforced the rule that every form of compensation for personal services received by all employees arising from employer-employee relationship is deemed subject to income tax, and consequently to withholding tax unless specifically exempted by or excluded by the tax code and the duty of the government as an employer to withhold and remit the correct amount of withholding taxes due thereon. The court also upholds the validity of Section 7, which prescribes penalty in case of noncompliance of withholding agents of their obligations. Verily, tested against the provisions of the tax code, the subject RMO does not define a crime and prescribe a penalty thereof. Section 7 simply mirrors the relevant provisions of the NIRC of 1997 as amended on the penalties for the failure of the withholding agent to withhold and remit the correct amount of taxes. However, with respect to Section 6, which enumerates the persons responsible for withholding, the court finds that the CIR overstepped the boundaries of its authorities to interpret the provisions of the tax code. Nowhere in the NIRC of 1997 as amended, or in RR number 2-98 as amended, would one find the provincial governor, mayor, barangay captain, and the head of government office, or the official holding the highest position such as the president, chief executive officer, governor, general manager, or in agency or GOCCs as one of the officials required to deduct, withhold, and remit the correct amount of withholding taxes. The CIR, in imposing upon these officials the obligation not found in law nor in the implementing rules, did not merely issue an interpretative rule designed to provide guidelines to the law which it is in charge of enforcing, but instead supplanted details thereon, a power duly vested by law only to the Secretary of Finance under Section 244 of the Tax Code. Letter B. Yes, the assailed provisions of RMO number 23/2015 are constitutional and do not contravene the constitutional guarantee of equal protection. The Equal Protection Clause is not violated by an executive issuance which was issued to simply reinforce existing taxes applicable to both the private and public sector. The withholding tax system embraces not only the private sector, but also covers the government of the Philippines, its agencies, instrumentalities, and political subdivisions, while the assailed RMO is a directive to the government. It did not, in any manner or form, alter or amend the provisions of the tax code for or against the government or its employees. Taxation law, income tax, tax on corporation, exemptions from tax on corporation. Case on income tax, exemptions from tax on corporations. Commissioner of Internal Revenue versus JP Morgan Chase Bank, Philippine Customer Care Center. TR 210-528, November 28, 2018. On May 1, 2007, JP Morgan Chase Bank, Philippines, entered into an agreement with People Support Philippines, a Philippine Economic Zone Authority, registered economic zone IT export enterprise, which enjoys income tax holiday period from May to July 2007. Under the agreement, People Support would provide the lease transmission facilities to JP Morgan Philippines for a fee. From May to July 2007, JP Morgan Philippines paid to People Support its fee and withheld the corresponding tax. JP Morgan Philippines filed its monthly remittance return of creditable income taxes withheld for July and paid the tax which included the amount withheld from People Support. However, after having realized that it erroneously withheld taxes on its payment to People Support, JP Morgan Philippines reimbursed the People Support said amount and likewise filed before the Bureau of Internal Revenue on April 7, 2008, an application for refund of the amount of tax erroneously withheld. However, due to the latter's inaction, JP Morgan Philippines filed on August 10, 2009, a petition for review before the Court of Tax Appeal. The CDA division denied the claim for refund, stating that the lease of transmission facilities was outside People Support's registered activities with PEZA. Thus, the income from the lease was subject to regular income tax and was properly withheld. However, upon a motion for reconsideration filed by the Commissioner on Internal Revenue, CDA division reversed itself and granted a claim for refund. The CDA and bank affirmed the resolution on appeal. Hence, this present recourse before the Supreme Court. Issue: is the income derived by People Support from the lease of its facilities to JP Morgan Philippines exempt from income tax? Ruling: no. Under BIR rulings and the PISA Memorandum Circular, registration of an activity with PEZA is an essential requirement to enjoy incentives under the law, and only income arising from or directly related to the conduct of the Ecozone enterprises registered activities are covered by tax incentives under the Philippine Economic Zone Act of 1995. People Support is registered with PEZA as an Economic Zone Information Technology or Export Enterprise, not an Information Technology Facilities Provider or Enterprise. Providing information technology enabled services is different from providing information technology facilities, infrastructure, or equipment. A perusal of the agreement between JP Morgan Philippines and People Support would show that the agreement pertains to the provision of physical plant space, voice and data infrastructure, all workstation infrastructure, and platform and support for inbound telemarketing services. In essence, People Support's leasing services to JP Morgan Philippines are in the nature of a facilities provider or enterprise and not information technology enabled services. As such, the agreement, which is essentially a lease of facilities, is outside People Support registered activities and thus is subject to income tax. The tax is properly withheld. Concept of withholding taxes. Commissioner of Internal versus La Flor de la Isabela. GR 211289, January 14, 2019. Facts. La Flor de la Isabela, or La Flor, filed monthly returns to the expanded withholding tax EWT and withholding tax on compensation WTC for calendar year 2005. On January 7, 2010, La Flor received 4 formal letters of demand and final assessment notices, or FAN. 1 for penalties for late filing and payment of WTC, 2 for penalties for late filing and payment for EWT, 3 for deficiency assessment for EWT, and 4 for deficiency assessment for WTC. They were all dated December 17, 2009 and covered deficiency taxes from the taxable year 2005. The Commissioner of Internal Revenue issued a final decision on disputed assessment, or FDDA, against La Flor involving the alleged deficiency withholding taxes. Aggrieved, La Flor filed a petition for review before the Court of Tax Appeals. The CDA division ruled in favor of La Flor and canceled the assessment. The CDA in bank affirmed the decisions of the CDA division. The CIR, in its petition to the Supreme Court, forwards a novel theory that Section 203 is inapplicable in the present assessment of EWT and WTC deficiency against La Flor. It argues that withholding taxes are not contemplated under the said provision, considering that they are not internal revenue taxes but are penalties imposed on the withholding agent should it fail to remit the proper amount of tax withheld. Issue. Are withholding taxes internal revenue taxes covered by Section 203 of the National Internal Revenue Code? Ruling, yes. In Chamber of Real Estate and Builders Associations versus Honorable Executive Secretary Romulo, the court had succinctly explained that the method of withholding tax at source is a procedure of collecting income tax which is sanctioned by our tax laws. Under the current system, the payee is the taxpayer, the person on whom the tax is imposed, while the payer, a separate entity, acts as the government's agent for the collection of the tax in order to ensure its payment. As a consequence of this system, two distinct liabilities arise, one for the income earner or payee, and another for the withholding agent who is a mere tax collector, not a taxpayer. The agent is not liable for the tax as no wealth flowed into him. The tax code only makes the agent personally liable for the breach of its legal duty to withhold the tax and remit the same to the government. Nonetheless, the court does not agree with the CIR that withholding tax assessments are merely an imposition of penalty on the withholding agent and thus outside the coverage of Section 203 of the NIRC. The CIR cites National Development Company versus Commissioner of Internal Revenue as basis that withholding taxes are only penalties imposed on the withholding agent. In effect, therefore, the imposition of the deficiency taxes on the NDC is a penalty for its failure to withhold the same from the Japanese shipbuilders. A careful analysis of the above quoted decision, however, reveals that the court did not equate withholding tax assessments to the imposition of civil imposed on tax deficiencies. The word penalty was used to underscore the dynamics in the withholding tax system. It is the income of the payee being subjected to tax and not of the withholding agent. It was never meant to mean that withholding taxes do not fall within the definition of internal revenue taxes, especially considering that income taxes are the ones withheld by the withholding agent. Withholding taxes do not cease to become income taxes just because it is collected and paid by the withholding agent. Thus, withholding tax assessments such as EWT and WTC clearly contemplate deficiency internal revenue taxes. Their aim is to collect unpaid income taxes and not merely to impose a penalty on the withholding agent for its failure to comply with its statutory duty and therefore are within the application of Section 203 of the NIRC. Again, for reference, EWT is expanded withholding tax and WTC is withholding tax on compensation. Case on value added tax, VAT exempt transactions. Commissioner of Internal Revenue versus Negros Consolidated Farmers Multi-Purpose Cooperative, December 5, 2018. Facts. Negros Consolidated Farmers Multi-Purpose Cooperative, or COFA, is a multi-purpose agricultural cooperative. Its farmer members deliver the sugarcane produce to be milled and processed in COFA's name with the sugar mill refinery. Before the refined sugar is released by the sugar mill, however, an authorization allowing the release of refined sugar, or AARRS, from the Bureau of Internal Revenue is required from COFA. For several instances, the BIR issued the AARRS without requiring COFA to pay advance VAT pursuant to COFA's tax exemption. However, in 2009, the BIR Bacolod required as a condition for the issuance of the authorization allowing the release of refined sugar, or AARRS, the payment of advance VAT on the premise that COFA is not the producer of the sugarcane to be refined by the sugar refinery under Revenue Regulation 13-2008 or RR 13-2008. COFA thus paid advance VAT under protest and sought the legal opinion of the BIR Legal Division, who stated that COFA is considered as the actual producer of the sugar cane because it primarily provided the various production inputs, capital, and technology transfer and farm management. In a ruling by the BIR, it stated that the sales of sugar produce by COFA to its members and non-members are exempt from VAT. With that said, COFA filed an administrative claim for refund with the Commissioner of Internal Revenue. Because of the CIR's inaction, COFA brought the case for review with the Court of Tax Appeals, who ordered the refund of the advance VAT to COFA. Issue: is COFA exempt from paying VAT and thus are likewise exempt from advance VAT? Ruling: yes, COFA is exempt from paying VAT and advance VAT. While the sale of raw sugar, an agricultural product, in its original state is exempt from VAT, the sale of refined sugar, on the other hand, is not so exempted, as refined sugar already went several refining processes and is no longer considered in its original state. However, if the sale of the sugar, whether raw or refined, was made by an agricultural cooperative to its members or non-members, such transaction is still VAT exempt. As regards the BIR issued RR 13-2008, it requires that for an agricultural cooperative to be exempted from the payment of advance VAT on refined sugar, it must be a cooperative in good standing, duly accredited and registered with the Cooperative Development Authority, and B, the producer of the sugar. COFA is a VAT-exempt agriculture cooperative. It is likewise established that COFA is a cooperative in good standing and was duly accredited and registered with the CDA as evidenced by the issuance of the CDA certificates of registration. Similarly, COFA is considered the producer of the sugar since its members, farmers, provide the sugar cane it refines. Having established that COFA is a cooperative in good standing and duly registered with the CDA and is the producer of the sugar, COFA's sale then of refined sugar, whether sold to members or non-members, is exempt from VAT. As a logical and necessary consequence of its VAT exemption, COFA is likewise exempted from the payment of advance VAT. Note, the CIR breeds confusion when it argues that the VAT exemption given to cooperatives under the laws pertain only to the sale of the sugar, but not to the withdrawal of the sugar from the refinery. The withdrawal from the sugar refinery by the cooperative is not the incident which gives rise to the imposition of VAT, but the subsequent sale of the sugar. If at all, the withdrawal of the refined sugar gives rise to the obligation to pay the VAT on the would-be sale. In other words, the advance VAT which is imposed upon the withdrawal of the refined sugar is the same VAT which would be imposed on the sale of refined sugar following its withdrawal from the refinery, hence the term advance. It is therefore erroneous to treat the withdrawal of the refined sugar as a tax incident different from or in addition to the sale itself. Irrevocability rule. University Physician Services Management versus Commissioner of Internal Revenue, March 7, 2018, GR 205955. Facts: University Physician Services Incorporated, Management Incorporated, or UPS-IMI, is a corporation that filed its 2006 annual income tax return, which reflected an income tax overpayment. In the same ITR, UPS-IMI elected the option to be issued a tax credit certificate with respect to its unutilized excess creditable taxes for the taxable year ending December 31st, 2006. The next year, UPS-IMI changed from calendar year to fiscal year, and so it filed an annual income tax return covering the short period fiscal year ending March 31, wherein UPSIMI opted to carry over as prior year's excess credits the 2006 income tax overpayment, which included the 2006 unutilized creditable withholding tax. UPSIMI also amended the return by excluding the sum subject of the refund claim from the line prior year's excess credits. Issue: does the irrevocability rule apply exclusively to the carryover option? Ruling: yes, the irrevocability rule applies exclusively to the carryover option. The irrevocability rule enshrined in Section 76 of the National Internal Revenue Code is limited only to the option of carryover, such that a taxpayer is still free to change its choice after electing a refund of its excess tax credit. Once a taxpayer opts to carry over its excess creditable tax after electing refund or issuance of a tax credit certificate, the carryover option becomes irrevocable. Accordingly, the previous claim for refund, even if subsequently pursued, may no longer be granted. In this case, UPSIMI may not be entitled to the refund of its 2006 excess tax when it thereafter filed its income tax return for the short period ending March 31st, 2007, indicating the option to carry over. However, UPSIMI is still entitled to the benefit of carryover and thus may apply the 2006 overpaid income tax as a tax credit in succeeding taxable years until fully exhausted, since the option of carryover under Section 76 is not subject to any prescriptive period, unlike the remedy of refund or tax credit certificate. Another case, Rhombus Energy versus Commissioner of Internal Revenue, GR 206362, August 1st, 2018. Facts: Rhombus Energy Incorporated filed its 2005 annual income tax return, wherein it indicated that its 2005 excess creditable withholding tax, amounting to 1.5 million, was to be refunded. The following year, the same amount was reflected as prior year's excess credits in Rhombus Energy's first, second, and third quarterly income tax returns. Then on December 29, 2006, Rhombus Energy filed a claim for refund of its 2005 excess or unutilized CWT, or creditable withholding tax. In 2007, Rhombus Energy filed its 2006 annual ITR, showing prior year's excess credits of 0. Issue: is Rhombus Energy barred by the irrevocability rule in claiming for the refund of its excess and or unutilized creditable withholding tax? Ruling: no. Rhombus Energy is not barred by the irrevocability rule in claiming for the refund of its excess and or unutilized creditable withholding tax. Section 76 of the NIRC of 1997 is clear and unequivocal in providing that the carryover option, once actually or constructively chosen by a corporate taxpayer, becomes irrevocable. Although Rhombus Energy had actually exercised the option to be refunded, Rhombus is not barred by the irrevocability rule in claiming for the refund of its excess and or unutilized creditable withholding tax. The irrevocability rule takes effect when the option is exercised. The Supreme Court held that Rhombus Energy, in marking the box to be refunded in its 2005 annual ITR, constituted its exercise of the option, and from then onwards, Rhombus Energy was precluded from carrying over the excess creditable withholding tax. The fact that the prior year's excess credits were reported in Rhombus Energy's 2006 first, second, and third quarterly RTRs did not reverse the option to be refunded, which was exercised in its 2005 annual ITR. All told, Rhombus can validly claim for refund. Period to file administrative claim for refund: KEPCO Ilijan Corporation versus Commissioner of Internal Revenue, GR 205185, September 26, 2018. Facts: KEPCO Ilijan Corporation is engaged in the production and sale of electricity to the National Power Corporation, NPC. It filed a claim for refund in April 13, 2004 for the VAT incurred in taxable year 2002. On April 12, 2002, KEPCO filed its petition for review before the Court of Tax Appeals. The CDA granted the refund, but only as to KEPCO's unutilized excess input VAT attributed to its zero-rated sales to NPC for the second, third, and fourth quarters of 2002. The claim for the first quarter was denied on the ground of prescription. KEPCO moved for partial reconsideration, arguing that its claim for the first quarter should not be denied because the rules and jurisprudence then prevailing stated that the reckoning period of the 2-year period for filing the claim for refund of unutilized input taxes was the date of filing of the return and payment of the tax due. However, the CDA denied the entire claim, opining that it did not acquire jurisdiction because of non-observance of the periods provided under the National Internal Revenue Code. Upon appeal, the CDA en banc affirmed the decision of the CDA in division, hence this petition. Issue: should KEPCO's input VAT claim for the first quarter of taxable year 2002 be denied? Ruling is yes. Under the Section 112 of NIRC, a VAT registered taxpayer claiming a refund or tax credit of excess and unutilized input VAT must file the administrative claim within 2 years from the close of the taxable quarter when the sales were made. Specifically, the close of the quarters of taxable year 2002 took place on March 31, 2002, June 30, 2002, September 30, 2002, and December 31, 2002, giving KEPCO until March 31, 2004, June 30, 2004, September 30, 2004, and December 31, 2004, within which to file its administrative claims for the first, second, third, and fourth quarters. respectively. Under the circumstances, KEPCO had belatedly filed its administrative claim corresponding to the first quarter of taxable year 2002, as the claim for refund was only made on April 13, 2004. Notwithstanding, the claims for the refund of the input taxes corresponding to the second and fourth quarters were timely filed. Period to file judicial claim for refund. Team Zual Corporation versus CIR. GR 201225 until 26, April 18, 2018. Facts. On December 6, 2000, Team Zual Corporation, or TSC, filed with the Bureau of Internal Revenue an application for zero rating. The same was approved. As a result, TSC filed its value-added tax returns for the first, second, third, and fourth quarters of the said year. TSC reported excess input VAT. On March 20, 2003, TSC filed with the BIR an administrative claim for refund of its aforesaid unutilized input VAT. On March 31st, 2003, without waiting for the resolution of its administrative claim for refund or tax credit, TSC filed with the Court of Tax Appeals Division a petition for review. It prayed for the refund or issuance of a tax credit certificate for its alleged unutilized input VAT for the first quarter of taxable year 2001. On July 23, 2003, TSC filed another petition for review seeking the refund or issuance of a tax credit certificate for its alleged unutilized input VAT for the second, third, and fourth quarters of taxable year 2001. Issue: was TSC entitled to its two judicial claims for tax refund? Ruling: TSC is only entitled to its second judicial claim for refund. Section 112, letter D of the NIRC provides that the Commissioner has 120 days to act on an administrative claim. This 120-day period is mandatory and jurisdictional. Accordingly, a taxpayer can file a judicial claim either only within 30 days, that's number one, after the Commissioner partially or fully denies the claim within 120-day period, or two, only within 30 days from the expiration of the 120-day period if the Commissioner does not act within such period. The taxpayer cannot file the judicial claim prior to the lapse of the 120-day period unless the CIR partially or wholly denies the claim within such period. TSC's administrative claim was filed on March 20, 2003, giving the CIR 120 days or until July 18, 2003 to act on the same. Thus, the first judicial claim was prematurely filed because TSC filed it 11 days after filing its administrative claim. On the other hand, the second judicial claim filed by TSC, filed on July 23, 2003, or 5 days after the lapse of the 120-day period, was filed timely. Therefore, the CTA Division only acquired jurisdiction over TSC's second judicial claim for refund. Another case, San Roque Power Corporation versus Commissioner of Internal Revenue, and that is GR 203249, July 23, 2018. Facts: San Roque Power Corporation, or San Roque Power, was granted by the Bureau of Internal Revenue with a zero rating on its sales of electricity. Later, on December 22, 2005 and February 27, 2006, San Roque Power filed two separate administrative claims for refund of its alleged unutilized input tax. The Commissioner of Internal Revenue failed to act on them. This prompted San Roque Power to file petitions for review before the CTA. The first petition was filed on March 30, 2006, and the second on June 30, 2006. The CTA and bank dismissed the petitions on the ground that San Roque Power's judicial claim were prematurely filed in violation of the 120-day and 30-day periods prescribed in Section 112, letter D of the National Internal Revenue Code. Issue: were the judicial claims of San Roque Power prematurely filed? Ruling: yes. The judicial claims of San Roque Power were prematurely filed. Section 112, letter D of the NIRC provides that the Commissioner has 120 days to act on an administrative claim. This 120-day period is mandatory and jurisdictional. Accordingly, a taxpayer can file a judicial claim either 1. Only within 30 days after the Commissioner partially or fully denies the claim within the 120-day period, or 2. Only within 30 days from the expiration of the 120-day period. If the Commissioner does not act within such period, the taxpayer cannot file the judicial claim prior to the lapse of the 120-day period, unless the CIR partially or wholly denies the claim within such period. The taxpayer claimant must strictly comply with the mandatory period by filing an appeal to the CDA within 30 days from such inaction. Otherwise, the court cannot validly acquire jurisdiction over it. In this case, San Roque Power timely filed its administrative claim for refund or credit of its unutilized input VAT on December 22, 2005 and on February 27, 2006 respectively, or within the 2-year prescriptive period. The CIR had 120 days or until April 13, 2006 with respect to the first administrative claim and until June 27, 2006 on the second administrative claim to decide. However, San Roque Power, without waiting for the full expiration of the 120-day period, immediately filed its petition for review with the Court of Tax Appeals on March 30, 2006, or a mere 98 days for the first administrative claim, and on June 20, 2006, or only 113 days for the second administrative claim from the submission of the said claims. For having been filed within the 120-day period where the CIR may act on the administrative claims, the judicial claims of San Roque Power were prematurely filed. Another case, KEPCO Illegent Corporation and Commissioner of Internal Revenue, September 26, 2018, GR 205185. Facts: KEPCO Illegent Corporation is engaged in the production and sale of electricity to the National Power Corporation. On April 13, 2004, it brought its administrative claim for refund before the Bureau of Internal Revenue. 9 days later, or on April 22, 2004, KEPCO filed its judicial claim for refund before the Court of Tax Appeals. KEPCO did not await the lapse of the 120-day period provided under the National Internal Revenue Code, leading the Court of Tax Appeals and Bank to declare that KEPCO's appeal is premature. KEPCO moved for reconsideration, arguing that its claim should not be denied because the rules and jurisprudence then prevailing stated that the reckoning point of the 2-year period from filing the claim for a refund of unutilized input taxes was the date of filing of the return and payment of the tax due. However, the CDA denied the entire claim, opining that it did not acquire jurisdiction because of non-observance of the periods provided under the NIRC. The CDN Bank affirmed the decision of the CDA and Division on appeal. Hence, this petition issue: was the judicial claim timely filed? Ruling: yes. In IT, the court clarified that the 120-day period was mandatory and jurisdictional. Hence, the non-observance of the period was fatal to the filing of the judicial claim in the CDA. However, in San Roque, the court acknowledged an instance when a premature filing in the CDA was allowed. The mandatory and jurisdictional nature of the 120-30 period rule does not apply to claims for refund that were filed during the interim period from the issuance of BIR ruling number DA 489/03 on December 10, 2003 to October 6, 2010, when the IT doctrine was adopted. In this case, KEPCO filed its administrative and judicial claims for refund on April 13, 2004 and April 22, 2004 respectively. Both claims were filed after BIR ruling number DA 489/03 was issued on December 10, 2003, but before the promulgation of the IT pronouncement on October 6, 2010. Thus, notwithstanding the petitioners having filed its judicial claim without waiting for the decision of the respondent or for the expiration of the 120-day mandatory period, the CDA could still take cognizance of the claims because they were filed within the period exempted from the mandatory and jurisdictional 120-30 period rule. Invoicing requirements. Nippon Express Philippines Corporation versus Commissioner of Internal Revenue, GR 191495, July 23, 2018. Facts. Nippon Express filed an application for tax credit of its excess or unused input taxes attributable to zero-rated sales. The Bureau of Internal Revenue failed to act on said application. In a petition for review before the Court of Tax Appeals, the Commissioner of Internal Revenue raised the defense that Nippon Express presented sales invoices to substantiate its zero-rated sales of services which, under Section 108 of the National Internal Revenue Code of 1997, as amended, require official receipts. Issue. Can Nippon Express successfully claim for VAT refund? Ruling no. Nippon Express cannot successfully claim for VAT refund. The burden of a claimant who seeks a refund of his excess or unutilized creditable input VAT pursuant to Section 112 of the NIRC is twofold. 1. Prove payment of input VAT to suppliers, and 2. Prove zero-rated sales to purchasers. When a VAT taxpayer claims to have zero-rated sales of services under Section 108 of the NIRC, it must substantiate the same through valid VAT official receipts, not any other document, not even a sales invoice, which properly pertains to a sale of goods or properties under Section 108. In this case, the documentary proof presented by Nippon Express to substantiate its zero-rated sales of services consisted of sales invoices and other secondary evidence like transfer slips, credit memos, cargo manifests, and credit notes. It is very clear that these are inadequate to support their sales of services. Tax remedies under the NIRC, prescriptive period for assessment. Commissioner of Internal Revenue versus Philippines Shell Petroleum Corporation, GR 197945, July 9, 2018. Facts. Shell and Petron are domestic corporations that paid their excise tax liabilities with the Bureau of Internal Revenue through a tax debit memorandum issued in their favor by the Department of Finance by virtue of their tax credit certificates. Thus, excise tax returns for each of the taxable years of 1992 to 1997 were filed by Shell and Petron. Later, BIR sought to collect from Shell and Petron excise tax deficiencies pertaining to the covered years 1992 to 1997 through summary administrative remedies. However, the court held that this could not be done as the collection letters were issued without a prior assessment. Issues. Has the period for assessment already prescribed? Ruling is yes. The period for assessment has already prescribed. Under the 1977 National Internal Revenue Code, the governing law in this case, BIR had 5 years from the filing of excise tax returns to issue an assessment and/or file a court action for collection without an assessment. Here, Shell and Petron filed their returns for the covered years from 1992 to 1997. The 5-year prescriptive period under Section 319 of the 1977 NIRC would have prescribed accordingly from 1997 to 2002. Furthermore, as found in the 2007 Shell case and the 2010 Petron case, Commissioner of Internal Revenue failed to issue any valid assessment against Shell and Petron's alleged deficiency excise taxes for the covered years. Without a valid assessment, the 5-year period to assess continued to run and had in fact expired on these cases. Thus, CIR is already barred by prescription from issuing an assessment against Shell and Petron for deficiency excise taxes for the covered years. Note, the issues concerning the transfer TCC's validity, qualifications of the transfers of said TCCs, and the valid use of the TCCs to pay for excise tax liabilities had been finally settled in the 2007 Shell case and 2010 Petron case and are already barred from being re-litigated by the doctrine of res judicata in the concept of conclusiveness of judgment. Another case, Asian Transmission Corporation versus Commissioner of Internal Revenue, GR 230-861, September 19, 2018. Facts: Asian Transmission Corporation, or ATC, filed its annual information return of income taxes withheld on compensation and final withholding taxes and annual information return of creditable income taxes withheld, expended, or income payments exempt from withholding tax, respectively. Consequently, on various dates, ATC, through its representative, executed several documents denominated as Waiver of the Defense of Prescription under the Statute of Limitations of the National Internal Revenue Code, so waiver. ATC thereafter received a formal letter of demand from the Commissioner of Internal Revenue for tax deficiencies. ATC filed its protest letter in regard thereto, but a final decision on disputed assessment, or FDDA, was later served on ATC, stating its liability for the deficiency tax. ATC filed an appeal letter for reconsideration, which was denied, hence the instant petition for review before the Court of Tax Appeals. The CDA Second Division held that ATC was not stopped from raising the invalidity of the waivers, as Bureau of Internal Revenue itself had caused the defects of the waiver, namely: A. The waivers were notarized by its own employee despite not being validly commissioned to perform notarial acts. B. The BIR did not indicate the date of its acceptance. C. The BIR did not specify the amounts of and the particular taxes involved. And D. CIR did not assign the waivers despite the clear mandate of RMO number 20-90 to that effect. However, the above-mentioned defects rendered the waivers invalid. Such waivers then did not operate to toll or extend the 3-year period of prescription. On petition for review, the CDA and Bank reversed and set aside the decision of the CDA Second Division and held that the waivers were valid. It held that CIR's right to assess deficiency withholding taxes against ACT had not yet prescribed. Issues, or issue: are the waivers executed by ATC valid, which operate to extend the 3-year period of prescription to assess deficiency taxes? Ruling: yes. Adopting the ruling in CIR versus Next Mobile Incorporated, the court declared that as a general rule, a waiver of statute of limitations in taxes that did not comply with the requisites for validity specified in RMO number 20-90 and RDAO 01-05 is invalid and ineffective to extend the prescriptive period to assess the deficiency taxes. However, as an exception to the rule, the following waivers could not be treated as an exemption and valid for the reason that the parties are in pari delicto, or in equal fault. In this case, the CDA and Division noted that the 8 waivers of ATC contained the following defects to it. A. The notarization of the waivers was not in accordance with the 2004 Rules on Notarial Practice. B. Several waivers clearly failed to indicate the date of acceptance by the Bureau of Internal Revenue. C. The waivers were not signed by the proper revenue officer. And D. The waivers failed to specify the type of tax and the amount of tax due. But these defects are not solely attributable to the BIR. RD A0105 indicates that the proper preparation of the waiver was primarily the responsibility of the taxpayer or its authorized representative signing the waiver. Such responsibility did not pertain to the BIR as the receiving party. The execution of the waivers was to the advantage of ATC because the waivers would provide ATC sufficient time to gather and produce voluminous records for the audit. Yet, after enjoying these benefits, ATC challenges the validity of these waivers only after the final assessment proved to be adverse. On the other hand, BIR's negligence in the performance of its duties was so gross that it also amounted to bad faith. Since the parties are both at fault, they shall have no action against each other. Therefore, the CDA and bank did not err in ruling that ATC, after having benefited from the defective waivers, should not be allowed to assail them. The 8 waivers are thus considered valid. Another case, suspension of the running of the statute of limitations. Commissioner of Internal Revenue versus LaFleur Della Isabella Incorporated. GR number 211289, January 14, 2019. Facts. LaFleur Della Isabella, or LaFleur, filed monthly returns for the expanded withholding tax, or EWT, and withholding tax on compensation, or WTC, for calendar year 2005. On September 3, 2008, LaFleur, through its president, executed a waiver of the statute of limitations waiver in connection with its internal revenue liabilities for the calendar year ending December 31, 2005. On February 16, 2009, it executed another waiver to extend period of assessment until December 31, 2009, and then another one on December 2, 2009. On January 7, 2010, LaFleur received 4 formal letters of demand and final assessment notices, or FAN, all dated December 17, 2009, and covered deficiency taxes for the taxable year 2005. LaFleur contested the assessment through a letter of protest. Thereafter, Commissioner of Internal Revenue issued a final decision on disputed assessment FDTA against LaFleur involving the alleged deficiency withholding taxes. Aggrieved, LaFleur filed a petition for review before the CDA, or Court of Tax Appeals Division. The CDA Division ruled in favor of LaFleur and canceled the assessments. The appellate court pointed out that the CIR only issued that FANs only on December 17, 2009. Thus, the assessment was barred by prescription. It was held that the waivers entered into by the CIR and LaFleur did not effectively extend the prescriptive period for the issuance of the tax assessment for the reason that only February 16, 2009 waiver was the only one stipulated upon, since the other 2 waivers were never offered in evidence. In addition, the waiver dated February 16, 2009 did not comply with Revenue Memorandum Order, or RMO number 2090, because it failed to state the nature and amount of the tax to be assessed. The CDA and bank affirmed the decision of the CDA Division, hence the present petition issue. Did the waivers executed by LaFleur extend the running of the prescriptive period for the issuance of tax assessment? Ruling no. In Commissioner of Internal Revenue versus Systems Technology Institute, the court had ruled that waivers extending the prescriptive period of tax assessments must be compliant with RMO number 2090 and must indicate the nature and amount of the tax due. These requirements are mandatory and must strictly be followed. The court, in a number of cases, did not hesitate to strike down waivers which failed to strictly comply with the provisions of RMO 2090. The Supreme Court also stated in Commission of Internal Revenue versus Standard Chartered Bank that a waiver of the statute of limitations is a bilateral agreement between the taxpayer and the BIR to extend the period to assess or collect deficiency taxes on a certain date. Logically, there can be no agreement if the kind and amount of the taxes to be assessed or collected were not indicated. In the present case, the September 3, 2008 February 16, 2009, and December 2, 2009, waivers failed to indicate the specific tax involved and the exact amount to be assessed or collected. These details are material as there can be no true and valid agreement between the taxpayer and the CIR absent this information. Clearly, the waivers did not effectively extend the prescriptive period under Section 203 on account of their invalidity. Therefore, the assessment made by the CIR on Lafleur had prescribed that there was no valid waiver. Issuance of Preliminary Assessment Notice. Commissioner of Internal Revenue versus Bank of the Philippine Islands, TR 224327, June 11, 2018. Facts. City Trust Banking Corporation or CBC filed its annual income tax returns or AITR for taxable year 1986 on April 15, 1987. Thereafter, on August 11, 1989, July 12, 1990, and November 8, 1990, CBC executed waivers of the Statute of Limitations under the National Internal Revenue Code. On March 7, 1991, the Commissioner of Internal Revenue issued a Pre-Assessment Notice or PAN against CBC for deficiency income taxes, to which CBC's counsel filed its protest on April 22, 1991. Another letter with attached assessment notices was issued by the CIR on May 6, 1991, to which CBC's counsel filed its protest on May 27, 1991 and February 17, 1992. Subsequently, a compromise settlement was reached between CBC and CIR, but when the CBC made a request for the final reconsideration of compromise settlement, the CIR disapproved the same and ordered CBC to pay its tax deficiency liabilities. Later, the CIR issued a warrant of distraint and or levy against Bank of the Philippine Islands, BPI. The articles of merger between BPI and CBC having been approved by the Securities and Exchange Commission or SEC beforehand, with BPI as the surviving corporation. Thus, BPI filed a petition for review with the Court of Tax Appeals, wherein the court ruled that the assessment notices, being issued only on May 6, 1991, were already issued beyond the 3-year period to assess, counting from April 15, 1987, when CBC filed its AITR for the taxable year 1986. The same court also held that the waivers of statute of limitations executed on July 12, 1990 and November 8, 1990 were not in accordance with the proper form of a valid waiver pursuant to RMO number 2090. Thus, the waivers failed to extend the period given to the CIR to assess. The CDA and Bank denied CIR's motion for reconsideration, hence this petition before the Supreme Court. Issue: was there a valid notice of assessment issued by the CIR to BPI? Ruling: none. There was no valid notice of assessment issued by the CIR to BPI. Under the law, a valid notice of assessment is issued when it is sent, released, or mailed to the taxpayer. While a mailed letter is deemed received by the addressee in the ordinary course of mail, this is still merely a disputable presumption subject to controversy, and a direct denial of the receipt thereof shifts the burden upon the party favored by the presumption to prove that the mailed letter was indeed received by the addressee. In this case, BPI denies receiving the assessment notice, and the CIR was unable to present substantial evidence that such notice was indeed mailed or sent before the BIR's right to assess had prescribed, and that said notice was received by BPI. In fact, there was even an express admission on the part of the CIR that there was no proof that indeed the alleged final assessment notice was ever sent to or received by BPI. Therefore, the assessment notice dated May 6, 1991 should be deemed as the final decision of the CIR on the matter, in which BPI timely protested on May 27, 1991. Therefore, The CDA was correct in ruling that the CIR failed to prove that it sent a notice of assessment and that it was received by BPI. CIR's failure to prove the receipt of the assessment by BPI necessarily leads to the conclusion that no assessment was issued. Alright, and that is for part 1. Watch out for part 2. I'm going to upload it shortly. And so if you're not yet subscribed to our channel, go ahead and hit that subscribe button. You can also like and share. Thanks!